60 Minutes with Angela starts right now.
Across dispute resolution facilities across the world, it is recognized that diversity is part of the fairness of the process. Diversity allows a wider discussion as to an issue. You don't want your own culture to be dominant in a tribunal because that would not be fair to the other side.
Yes.
But you don't want yours to be obliterated. And why should you have a contract to be performed in Lagos and then go to Paris and ask three French guys to decide the factual matrix, which is entirely outside their understanding. The factual matrix of a contract is essential to interpreting it. If you can't understand that factual matrix, you immediately disadvantage those who are relying on that to justify their actions.
Well, hello and welcome. This is 60 Minutes with me, Angela Ajitomobi. Thank you for joining me on the program today. And joining me on the program is the president of the Lagos Court of Arbitration. I wonder if he's still a senior partner with his law firm, Strachan Partners, which he founded in 1994. He's been a senior advocate of Nigeria since 2003, holds a master's in law from the University of London, that in 1984. He's an author of many scholarly articles and also co-authored the book Commercial Arbitration Law and International Practice in Nigeria with Lagos State's former Attorney General, Shupo Shashore, also a senior advocate of Nigeria. He's been a notary public since 1988 and a fellow of the Chartered Institute of Arbitrators in England. He's an approved tutor and examiner with the UK Chartered Institute of Arbitrators. A member of the board of the Lagos Court of Arbitration since 2014. That court he now heads as president. He is an honorary fellow at the Center for International Legal Studies in Salzburg, Austria. So, join me after the break. I'm counting down 60 minutes with Yemi Candide-Johnson, Senior Advocate of Nigeria. Welcome back. Welcome, Mr. Candide-Johnson. Thank you for coming on the program.
It's my pleasure.
Now you're president of the Lagos Court of Arbitration, but I also introduced you as a member of the board since 2014. So there is a board. How does that work? What does that structure mean? You know, you being president and then there is a board there as well.
Well, the board is a group of people elected by the members of the Lagos Court of Arbitration. Of course, the original members at the time of foundation were nominated by the governor of Lagos, who was responsible for an endowment to support the vision which established Lagos Court of Arbitration in 2009, the new Lagos arbitration law, which was meant to be a model law for attracting arbitration to the territory of Lagos.
Yes.
The board is composed of 13 other individuals who are learned and experienced in arbitration, international arbitration, commercial mediation. And my job as president is basically to represent in the management of Lagos Court of Arbitration the will of the board.
So in preparing for this conversation, I came across two words or two phrases that are used interchangeably: alternative dispute resolution and arbitration. Is there a difference between the two, or do they feed off each other?
Well, arbitration is a form of alternative dispute resolution.
Right.
But arbitration is the most well-known form. People use the expression, as we do, arbitration and alternative dispute resolution to signify that there are other devices for alternative dispute resolution which we also promote: conciliation, mediation,
Yes.
Even early mutual evaluation. There are a variety of means, and anything that the parties agree by which their disputes can be resolved, which is outside what we recognize as the traditional system
Yes.
of justice, is ADR.
And you've worked on some really high-profile arbitrations as chairman or co-chairman, and I thought people in the areas you specialize in could benefit from listening to us. Why should anyone want to go by way of arbitration when the courts are there? Were courts not meant to settle disputes?
Well, it's helpful, I think, to define what arbitration is.
Yes.
I mean, conceptually, it is the resolution of disputes by people under voluntary process and by a non-governmental decider. So, by definition, it's
Yes.
outside the scope of the traditional system of courts. Now, it's interesting that we acquiesce in the description of this method as alternative.
Yes.
But in reality, across the world, and particularly in our African context, the traditional and most well-known system of resolving disputes is indeed by mediation, by arbitration. And in Lagos, for example,
Yes.
where this court is established, it's important to recognize that historically, what was alternative was the courts established by the King of England after the colonization of Nigeria. Before that time, for hundreds of years before then,
Yes.
I like to say that even when Lagos was a mosquito-infested swamp,
Yes.
where human sacrifice and slavery was the order of the day,
Yes.
merchants from across the world decided disputes to arose between them in the course of their trade by alternative means, well, means which we would now call alternative, but which were traditional and accepted. And those decisions were accepted as authoritative. Now, why should we promote that system of alternative dispute resolution today?
Yes.
Not just because it is convenient and it is natural, because the parties create it themselves and it has flexibility, it has privacy, the confidentiality, and depending on how you choose the tribunal, it can be far more effective in penetrating a dispute. For example, if you have a dispute about building and you choose an architect,
Yes.
that architect or a builder or an engineer may be better able to penetrate the dispute and quicker than a judge who has never built a house.
Yes.
In addition, the traditional courts are rather austere and forbidding atmosphere and difficult for ordinary people to approach.
Yes.
Added to that is the fact that in our context, and it's not just in the Nigerian context, but the burdening of courts with a variety of disputes,
Yes.
the entrustment to individuals who do not necessarily have trade experience to determine commercial disputes is recognized across the world
Right.
as an impediment to the prompt, efficient, and effective resolution of those disputes.
Because I have here increasing caseload of traditional courts. Arbitration, they say, imposes fewer costs than litigation. But in terms of costs, if you're moving to do the arbitration in any environment, are there no associated costs, accommodation, for instance, while the arbitration lasts? You know, who bears the costs of those things?
Well, the first thing I should say is that arbitration can be more expensive than litigation.
It can be more.
It's important to make the concession. It depends
Yes.
on the nature of arbitration. One of the principal challenges of arbitration in ADR across the world
Yes.
is controlling costs. And for this reason, a variety of methods are devised to create arbitration models for a variety of topics, and a variety of costs. For example, in labor disputes,
Yes.
or in entertainment, or in sports, or in master and servant, those are cases where you can have a more effective, controlled, and structured type of dispute resolution model, which can reduce costs. So the cost of the process itself may be high. If you have a multi-billion-dollar telecommunications or oil and gas dispute, the issues at stake are so high, and the parties so well resourced that they are willing to expend large amounts of money to resolve it according to their own understanding. So you're talking about paying huge amounts for particular arbitrators, paying huge amounts for teams of lawyers. Some arbitrations involving huge amounts of resources, you're talking that there could be millions of dollars worth of costs just for the process itself.
Right.
But you make another point about the logistics and the ancillary factors with arbitration. It's not
Yes.
just the dispute itself, but anytime you want to decide a dispute, you're effectively creating a mobile court system. And that court system involves moving individuals to different places, moving witnesses, giving them accommodation, taxis, air tickets, airfares, feeding.
Yes.
This whole support infrastructure, transcription, internet services.
Yes.
These are facilities which add to the cost. Not every arbitration will generate those costs. But in those circumstances, the location then becomes important, because for a Nigerian, for example,
Yes.
if you have to take your dispute with a French entity to Paris or to London or to New York. And there's a variety of reasons, including bargaining power, by which parties may decide where a dispute will be located.
Yes.
Then you have to bear in mind not just the cost of the process, but the cost of carrying your infrastructure with you. And that is a matter that bears some thinking about.
So I'm just thinking off the top of my head now, in drawing up an agreement that both parties will go through arbitration rather than the traditional courts, will these costs be included in that agreement?
You again identify a critical point. Because when people invariably do agreements,
Yes.
they are thinking about a number of other things other than disputes. They're thinking about when the check is going to be paid.
Yes.
Performance. In some respects, the arbitration clause is referred to as a midnight clause because at the last moment they say, oh, well, don't forget the arbitration clause. But because of the reality that disputes are almost inevitable in any commercial arrangement,
Yes.
it becomes critically important to decide at the point of agreement how your dispute will resolve. For example, it is the time to decide whether you want your dispute with a French company to take place in Paris
Or in Lagos?
or in Lagos. It's time to decide how many arbitrators. It's time to decide under what rules. It's time to decide what happens if there's an emergency.
Yes.
Many arbitral institutions have rules for dealing with a number of situations which parties can't recollect at the time they're doing an agreement. And this is why choosing the rules of a particular institution allows you to rely on their expertise, their vision and expectation from commercial disputes, and to say, well, if we're going to London or we're going to Lagos Court of Arbitration has rules which deal with a wide variety of situations. For
Yes.
example, if there's an emergency and you haven't constituted a court,
Yes.
what do you do? Well, we can provide interim solutions which parties hadn't thought about. So it's quite important. And also, where will this be decided? Can I afford to go to London if I have a dispute? Now, how those negotiations are resolved depend on the power of the parties. And traditionally, African institutions and African entities haven't historically had the economic power to be able to say, well, this is important to us.
Yes.
But they increasingly do. Nigerian entities, for example, increasingly telecommunications entities, oil and gas entities, banking entities have the power to say, we're coming to this table with equal bargaining power,
Yeah.
or we're entitled to the respect of our own thoughts, and we want to have this matter discussed. And when you do raise the point, increasingly people are accepting that. You know, the African Development Bank pointed out and quoted by a leading African arbitrator recently
Yes.
that maybe 99% of disputes involving Africa and African entities and international entities
Yes.
have a recourse to arbitration in London, Paris, or New York. And this is disadvantageous, not only by way of the location, but by way of who will decide those disputes.
Right.
Because he also pointed out that perhaps in 90% of those cases, the African party came off worse. And this is notwithstanding that they have incurred huge costs in constituting the tribunal,
Yes.
huge costs in paying often international law firms to decide
Yes.
the cases. Now, the statistics show an unnatural tendency, and it's possible to draw conclusions from those statistics. And the conclusion that I draw is that who decides your dispute is critical, and that if you don't participate in the system by which your disputes are resolved, you are automatically disadvantaged.
Another point that just came into my mind, talking about Nigerians now, I'm thinking of the culture. You know, when you're entering into a contract, thinking about the downside, going into arbitration, it's like admitting that this thing is going to fail. Is that something that you've come across? Do people get bothered that if we put arbitration, then it means that this thing is doomed to fail from the start? It's like inviting doom to the contract.
Yes, we're very superstitious Africans, but you know, I don't think superstition helps business results.
Yes.
You know, someone recently described the arbitration clause, and thinking about it similarly as you do, to a prenuptial agreement.
Yes.
You know, you're in love,
Yeah.
so why do you want to plan how you settle your property thereafter? Well, experience teaches that disputes do arise even in marriages.
Yes.
Often, having resolved it at that earlier stage may be advantageous. So people do have that. Africans don't want to write wills because they think it means they're plotting their death. We have to overcome, if you want to do business in the modern world and you don't want to suffer prejudice, you have to think carefully, and you have to recognize what is fact. It is a fact that disputes in commercial arrangements are almost inevitable. But if business people want progress in those business relations, they have to say, if a dispute arises, how can we resolve the dispute promptly, efficiently, effectively, so that we can continue to do business? And this is a key advantage of arbitration. It's not necessarily a death-defying fight such that you would expect if you went to court. You know, even stronger in our culture is that you've put a man to court. It's the end of friendship. But arbitration is not inconsistent with people continuing to do business after they've resolved the dispute by that system.
And so in choosing arbitrators, it is important, would you say, that people should choose arbitrators who are from their background? Is that the right way to put it? From their own environment? For instance, if I'm going into arbitration in Paris and all the arbitrators are international persons, there's no Nigerian arbitrator there who knows my background, my culture, my traditions. Is that a minus?
Yes, it is. You know, I don't want to state it in a tendentious way, but across dispute resolution facilities across the world, it is recognized that diversity is part of the fairness of the process. For example, in England, there have been big issues as to cultural and ethnic and national diversity on the High Court bench. If everybody appears before the English High Court and meets somebody who went to Cambridge and who lived in the home counties for all his life, he may not understand the perspective which you have, which may be legitimate. So the diversity allows a wider discussion as to an issue. And there are many cases where I could identify from the nature of those who decided what might be the result. You don't want your own culture to be dominant in a tribunal because that would not be fair to the other side. But you don't want yours to be obliterated. Because sometimes when we say something which someone may say, well, that's completely ridiculous. But it wouldn't be ridiculous if you said to somebody who was living in Lagos. And why should you have a contract to be performed in Lagos and then go to Paris and ask 3 French guys to decide the factual matrix, which is entirely outside their understanding. The factual matrix of a contract is essential to interpreting it. If you can't understand that factual matrix, you immediately disadvantage those who are relying on that to justify their actions.
Join us again after the break.
Nice question.
Angela, that's a great question.
It's a good question.
It is difficult to respond to that question.
That is a serious question.
Angela, that is a very great question. Great question, Angela.
You know, Angela, that's a very difficult question.
That's a great question, Angela.
Okay, that's a great question.
Angela, that's a tough one for me.
That's a good question. Good question.
I love to ask questions. I think it's what I do best. You see, I think that the fastest way to learn anything is to ask questions. The right questions, that is. Questions that help you get to the heart of the matter.
60 Minutes with Angela. Again, answers to every question you always wanted to ask.
Welcome back. If you've just joined us, it's 60 Minutes with me, Angela Ajitomobi, on my hot seat today. Yemi Candide-Johnson, the Senior Advocate of Nigeria and President of the Lagos Court of Arbitration. Now, I was reading about a New York Times study on the increasing use of arbitration clauses in contracts and found that millions of people were forced to sign away their rights to go to court. So, should arbitration be a suppressor of that universal right to go to court?
First of all, the right to go to court in a commercial context is often overstated. It may be more disadvantageous to the continuation of commercial relations if you have to go to court. But the regulation of arbitration in Nigeria, and this is based largely on the model law which the United Nations Commission on International Trade established first in 1998, I think it was, and then in 2006 there's a review. I may have got my dates wrong. But that law recognizes that arbitration exists with the support of the court system in many respects. One is that the ultimate result, if it is not adhered to by the parties voluntarily, must be enforced by the courts. If support is required in the course of arbitration, you resort to courts. But it is unlawful under the common law and under our constitution to oust the jurisdiction of the courts. So conceptually, regulation of arbitration recognizes that it is not an ouster of the jurisdiction of the courts. Rather, it is a voluntary submission, which means that if we have voluntarily submitted, that contractual right is also recognized by the courts. So if I have an agreement with you, we voluntarily agreed to go to arbitration. If you go to court, I go to court not to suppress your right to go to court, but to tell the court that we have an agreement And the court is bound to enforce that agreement. And what the court will do is, yes, we have jurisdiction. However, we will not exercise our jurisdiction because the parties have chosen to go to arbitration, and so we will stay the proceedings in the High Courts.
All right. So when you are done with arbitration, you can come back.
You can come back. I mean, once the arbitration has decided the dispute, the court no longer has jurisdiction because the matter has been decided. So, but if you need to enforce it and the parties don't accept it, you would go back to court. But the ambition of every arbitration is voluntary adherence. And that is a task for the arbitrators, because the arbitrators have to so conduct themselves that the parties, even the losing party, ought to accept that this is a fair process, this is a proper decision, and let's get back to business. So this is the challenge. Many awards are challenged, but the ambition of every arbitration is that the parties will say, it's a fair deal, let's move on.
There's also another case, a nursing home in Massachusetts, where arbitration clauses were added to complex contracts that were difficult to navigate, but yet required those residents to go to arbitration and not courts. So is it important that the process is not complex, is understandable by the ordinary man on the street?
Yes, you know, any system of justice, in my opinion, ought to be accessible. It ought to be easy to understand and to approach. Otherwise, there is a danger that a weaker party, less resourced party will be disadvantaged. And if that is the case, then the reputation of that system starts to fall away. The case you refer to is, there are many cases in American jurisprudence in particular, where in a variety of fields, even in labor law, even in telecommunications, often in banking, with telephone companies, where you take a contract, even online, you click a box, you're bound by a whole series of rules you've never read. And the purpose of those rules is to make it convenient for the large entity which is giving you those contracts to accept to do business. But in individual cases, it may disadvantage somebody who has a unique issue which is not contemplated by that system you've created, or by lack of accessibility, he then becomes unable to navigate it. And the courts recognize that in certain respects, I mean, public policy is an important part of the regime for dispute resolution and arbitration in particular. If you can prove that you are disadvantaged by a contract of adhesion, which you've been forced to abide by, and your consent is somehow imperfect, or there is great inconvenience with executing that system of dispute resolution, then I certainly am satisfied that you will be able to apply to the court and say, this is an unfair contract. And many systems of law also recognize that a contract that is inherently unfair is unenforceable.
Can arbitration commence without a valid arbitration agreement in writing between the parties? So we have an agreement and we agree orally that we will go into arbitration. Can either of us be held to that oral agreement?
It's an interesting question because, of course, fundamentally, an oral contract is still a contract. But for purposes of recognizing an arbitration agreement, the Nigerian law, ancestral model law, which is the United Nations law, recognize that arbitration agreements, particularly in the commercial context, must be in writing. Because you need to be able to say what are the terms, what are the scope, and you need to start with the foundation where no party can doubt agreement is reached. If someone says that an oral contract is as good as the paper it's written on.
And there's no paper there.
Exactly.
All right. The arbitration clause, must it be written into the body of the contract itself, or can it be on a paper that is attached to that contract? Under
the Lagos law, you can discover the elements of a written arbitral submission from a variety of sources. You can look for it in data, in exchange of emails, in written. Once you can construct a written evidence of that agreement, it's satisfactory. So the simple answer is it doesn't have to be in the contract that you're operating. It can be constructed from documents related thereto, or after. It's quite possible for parties who have a dispute to, after the dispute arises, agree that it's best for us to go to arbitration.
Rather than to court.
Exactly, and that happens often.
Okay, so it doesn't have to be on the start of the contract that we agree to arbitration. Any time along the way, the duration of that contract, it is still valid.
Sure, except it's more difficult. By the time disputes arise and people start getting entrenched positions and getting hostility, it's more difficult to agree about anything. The best time to agree is when you're good friends.
I like the way you put that, good friends. Can a party start the process of arbitration without the cooperation of the other party? In other words, even though we've agreed in writing, do I still have to tell you, say, look, Mr. Candide-Johnson, I think it's time for us to go into arbitration, and then you kicking and saying no. Do I need your cooperation to start that process?
Well, you don't need cooperation, but you need to give me notice. So arbitrations invariably begin with a notice of arbitration, which identifies the subject matter of the dispute, the contract, the issues of fact or issues of law, which identifies the clause by which arbitration has been chosen, and indicates almost inevitably by that notice that you've initiated the process by appointing an arbitrator. The other party has notice. This notice is a fundamental, because you cannot execute a system of dispute resolution without the other party having an opportunity to be heard.
Yes.
And if they don't have notice, they have no opportunity. This invalidates any result that may come out of that process.
And that notice will be in writing to you?
Yes.
Right. Will there be evidence that you have received the notice?
Well, there should be. If I issue a notice of arbitration, I will take it to the office of the other party and make sure someone stamped received it, or I send it by some sort of registered or recorded system of delivery, because you can't have one party denying receipts. So it's your job to make sure they can't deny they received the notice.
Do some parties go against the process when the resolution doesn't go their way after the arbitration has been concluded, even though we both agreed to go to it? I'm not happy with the way things have gone. Do parties go against that?
Now, this is a topical discussion. Historically, arbitration arose in specific trades, certainly international commercial arbitration, in the coffee trade, in the cocoa trade.
Yes.
And the way it worked is that many of these decisions were made by experts and respected individuals in the field. This is not unusual even in African traditional arbitration. I was reading recently about the ECPA Society in Calabar, which decided disputes. Now, those disputes carried the authority of the decider, and parties, for a variety of cultural and social reasons, did not dispute those decisions. And that's the way those systems were regulated. Increasingly, arbitration, especially international arbitration, involves parties from different countries. It involves deciders who are chosen because of the knowledge of law or different systems of law, who are not known to either of the parties, who have no inherent authority other than the quality of their product. Also, these arbitrations often involve huge amounts of money. Now, with those stakes, it is less likely that people are going to walk away without exercising every opportunity they have to test the result. Now, the challenge for the arbitrator is to so construct and so conduct the proceeding that it is difficult to interfere with his decision. And the challenge of each individual party is not to blindly adhere to the decision of the arbitrator. After all, there's no social or cultural reason why they should.
Yes.
But to be certain that the system is so important and so valued that their challenge must be well-founded, well-taken, and ultimately the law recognizes a recourse to the courts to examine in limited circumstances the decision of an arbitrator. And to take that opportunity is not something to be looked down upon.
Who appoints the arbitrator? Is it the parties who sit down and decide, I'll take Mr. Candide-Johnson, I'll take Mr. B, or,
There's a variety of processes, and there again it depends on what the parties agree. What is most usual and what is the default procedure under Nigerian law is that each party appoints one arbitrator, and the third is appointed by the two so appointed. So if you like, the third one holds the balance. There are other systems by which institutions appoint all three, or institutions appoint one, or institutions appoint the chairman. It depends on what the parties agree. But what I think is important to emphasize is that even when you're a party-nominated arbitrator, now the party is entitled to say, look, this is a matter involving telecommunications, so I want a lawyer who has experience in telecommunications. Or I want somebody who, from his recent pronouncements, is fairer to defendants or fairer to plaintiffs, or doesn't. These are relevant considerations. But once appointed, the arbitrator belongs to no party. He belongs to the procedure. So I see this very often. People slip.
You mean my arbitrator will be agreeing with the other side?
Exactly. My arbitrator.
Yes.
I've heard that said so often. But I remember sitting on a tribunal and my co-arbitrator kept saying, my client has said, and I kept saying to him, Chief, he's not your client. You stand here impartial.
Yes.
You have to be trusted. People ask me often, how do you get into international arbitration? And I've heard many people answer this. Very often it's by accident. But how do you stay?
Yes.
It's by your reputation for independence and impartiality. This is the key, because people have to trust that you're going to hear the case and you're going to decide according to your conscience, according to your understanding of law. You may be wrong, but what is expected of you is that you decide according to your understanding and according to the arguments in the case presented to you.
This is interesting. I thought arbitrator is like taking my lawyer, but what you're saying now, he's not beholden to me and my rights and my opinions.
He's not. And you know, as I said, you have a choice in who you appoint. And I would expect that the best you can expect from the arbitrator you appoint is that your case will be heard, and maybe he may take better notice of the points you've made. So when the discussion is going on, you say, "Oh, did you bear this in mind?"
Yes.
But ultimately, he has to decide according to the right. And so, in many cases, the arbitrator that you have appointed, and I've faced that myself,
Yes.
will decide contrary to your position. And the next day, I'll still say hello and hug them, and if they're smart enough, I might appoint them again.
Is there a list of arbitrators? Where do you appoint the arbitrator from? You know, is there somewhere where you get the list
Yes, the
of...
Lagos Court of Arbitration, as an example, and many
Yes.
other institutions do the same,
Yes.
has a list of neutrals.
All
This is
right.
what we call them. We have neutrals who will appoint, and the very name is instructive.
Yes.
And you can choose a neutral from our list. We publish the list of neutrals for the Lagos Court of Arbitration, both in mediation and in arbitration. And you can apply to the president of the Lagos Court of Arbitration and say, can you appoint a neutral because we have a telecommunications dispute? I then say, okay, let me look at the papers. What type of dispute is it? I would suggest this individual. You have to
Yes.
accept him or not.
Yes.
But because I have a better knowledge of those who are practicing in the field, I may be better able to give you a choice
Yes.
than you do. But then you can do it yourself. So ICC keeps its own list, as you can imagine. There may be more Europeans and Americans on the ICC list than
Yes.
there are Africans. And this is inevitable. This is part of what I speak about.
Yes.
The New York Ship Owners Association has its own list. The London Court of International Arbitration has its own list.
Yes.
The London Maritime Arbitrators Association has its own list. And so basically they're choosing people who they know.
Yes.
They're lending you the experience of the practitioners, and they're saying to you, we can suggest such an individual. So it depends on the clause. But traditionally, it's both parties choose one, and the two parties appointed arbitrators choose the chair.
The third.
Yes.
Are they all paid the same?
There shouldn't be a difference, or there shouldn't be an irrational and covert difference in the compensation of arbitrators. If one arbitrator got more than the others, it may well be suggestive of an undue influence. But in many arbitrations where one common fund is contributed,
Yes.
it is quite usual that the chairman takes 40% and the co-arbitrators take 30%.
Right.
But if the rules are that the arbitrators are paid directly according to their time or according to some other system, then it is usual that they would split the pot
Right.
3 ways. So that's the way it often
Who
applies.
pays the arbitrators?
The parties. The parties generally would contribute a fund from which the arbitrators would be paid. Very often the chairman or a particular institution may administer that fund
Yes.
and pay according to agreed rules as to how the system will be paid.
You've said that a party to an arbitration can still appeal the outcome of that resolution to a normal court. What will that court then do?
Specifically didn't use the word appeal,
Yes.
but that is the way people would
View
traditionally
it,
express it.
yes.
The fact is that there is no appeal from the decision of an arbitral tribunal. However, if the arbitral tribunal makes certain kinds of error, those errors will authorize a court to set aside the award.
Who decides that there's an error?
Well, if you think there's an error, you present it to a court and show what that error is. Now, the error is a limited field of errors. In the Lagos arbitration law, which is more fit for purpose than the federal arbitration law,
Yes.
the right to recourse to court is limited by substantial justice. So if an error is made and doesn't cause a substantial injustice, that would not allow the court to set aside. But under the traditional test,
Yeah.
which is misconduct, if an arbitrator makes an error which is jurisdictional, which affects his capacity to decide the question, if he decides something he wasn't meant to decide, if he doesn't decide something he should have decided, if he was bribed, if he was corrupt, we haven't defined with exactitude the expression misconduct.
Yes.
But a whole variety of technical errors as well as moral errors can be characterized as misconduct. And if there is misconduct, then the court can set aside the award.
What, in your opinion, would you say is the greatest disadvantage of arbitration?
You know, a properly managed arbitration
Yes.
should have no advantage that can't be corrected.
Right.
Because the parties can choose how they want the process to go. They can curtail time, they can curtail costs, they can curtail composition of the tribunal, they can even curtail the capacity to review the award thereafter. In some territories now, they have made rules. France is one example that you cannot challenge an arbitral award without having complied with it. And that makes it more difficult. I mean,
Yes.
even in our traditional court procedure, I think that it would help because of the proliferation of appeals on also ridiculous grounds, which impedes the progress of dispute resolution. If you said, you can appeal, but you must first comply, that would be helpful. So disadvantages, it's difficult to fix disadvantages when I say that anything you identify as a disadvantage, because the fundamental character of arbitration is that the parties decide how it works, the parties can cure it. So I'm afraid you can't lure me to find the disadvantages.
All right, join us again after the break. So what is 60 Minutes with Angela all about? It's not an interview. I like to think it's a conversation between two people making the news, people who are in the news, and those who become the news. And the whole idea is to inform, to educate, or to clarify, as the case may be. It is an art getting people to answer the questions that everyone is thinking in their minds. And that's what we try to do on 60 Minutes with Angela. I ask all the questions that everyone's thinking about and no one wants to voice. All the questions you always wanted to ask, you get those answers on 60 Minutes with Angela. Every week on this station, 60 Minutes with Angela, getting answers to every question you always wanted to ask. Well, welcome back. My concluding moments now with Yemi Candide-Johnson, a senior advocate of Nigeria and president of the Lagos Court of Arbitration. Does your work as president of the court prevent you from acting as counsel in arbitration cases?
My work as president, and I say this also for directors of the Lagos Court of Arbitration, is to some extent sacrificial. I mean, all the directors are listed as neutrals on the list of the LCA, but none of them will be appointed by the LCA.
Right.
Because of independence and impartiality, it's very important for people to know that we're not sharing out work to ourselves. But because they're highly qualified people there, so if the parties of their own choice decide to choose any of them to sit as an arbitrator, that's fine. But we won't choose ourselves. Now, for me as president in particular, it's doubly difficult because I have to make these choices. And in many respects, I would say that without making it a rule, that I can hardly contemplate an arbitration coming to the Lagos Court of Arbitration which I would be able to sit on. So even if somebody said to me, Mr. President, we'd like you to sit on the arbitration, my default decision would be, I'd rather appoint somebody else.
Yes.
Can I recommend another director or recommend another neutral? So you choose another director or I will appoint another neutral, because there's going to be difficulties at some point if I have to intervene in that process. Then where's my independence and impartiality? So the cost of maintaining your independence and impartiality is loss of income.
I can well imagine that. All right, let's talk about the first ICC Africa Regional Arbitration Conference. What does ICC mean?
ICC is the International Chamber of Commerce, which is a largely Eurocentric organization based in Paris, and which organizes dispute resolutions on a variety of international subjects and matters under the supervision of a committee which is called the Court. The Court of the ICC guides the procedure along with the Secretariat of Arbitrations, which have chosen ICC rules as a recourse and have chosen ICC administration. And it organizes neutrals and systems, and it also provides a review of awards to a certain limited extent, not to the merits, but technically. So it's a leading arbitral institution, highly respected across the world. And it's a business also, because it generates a huge amount of activity. Some say that the generation of arbitration is billions. I mean, someone was pointing out the other day that golf, which some may think is a sport, generates $7 billion.
Yes, not many people realize that.
Yeah, there you go. So arbitration also generates billions of dollars in costs and from its related activity. So it's very important for Paris, the ICC.
Right. And that conference held in Lagos from 19th of June to the 21st. It was the first conference in Africa. What was the vision of that conference? Why did that conference hold here?
I think that a conference like that is something for everybody. I think for the international practitioners who have come to speak and to participate in this conference,
Yes.
they do so because they want to be exposed to the value of the Nigerian economy, the opportunity to participate in dispute resolution in the largest African economy. They haven't come here out of the goodness of their hearts.
There's business here.
Absolutely, there's business to be had. But in addition, even for those, including young lawyers and arbitrators who participate and mix with these individuals, it's hugely beneficial. They get the value of their knowledge, their experience, they get to interact, they get to be exposed and to be known themselves.
Yes.
So there's benefits for everybody. There's benefits for those who don't have any exposure to international practitioners and practice, and there's benefit to those who come here so that they can increase their business portfolios.
You talked about alternative dispute resolution, and you said arbitration is just one part of it.
Yeah.
What are the other types of alternative?
Well, another major aspect is mediation. Many disputes are resolved by the parties agreeing that they want some individual that they trust, who they choose to discuss with them. And certainly in my experience, arbitration, because of the increasing lawyerization of arbitration,
Yes.
it starts becoming quite combative. Mediation is a far different atmosphere. Mediation, conciliation, whatever you choose to call it.
Yes.
Principal aspects.
What's the difference between?
Well, a mediation ends with an agreement. An arbitration ends with a decision, if you like, a judgment. The task of a mediator is to dispel sentiment and dispel emotion and things that impede the commercial progress of the arrangement.
Yes.
And I certainly found that in my experience that if you take two parties who have started a contract before,
Yes.
even like a husband and wife,
Yes.
and you keep them in different rooms and say, so what did he do and what didn't he do? Well, I'm not going to agree to these three things. You get a view and you say, this is what we'll do, this is what we won't do. You go and talk to the other person. Very often they have conceded in private things that they thought were irresoluble. So you go between the both. Finally, you reach a point where you say to them, right, I need to get you both together. These are the key points. He agrees these 6 points, you agree these 7 points. This is the one that's outstanding.
Yes.
But then you see what is between you is better than what is not between you.
Yes.
So can we not reach an agreement? And very often when you take away people's hurt and sense of offense and outrage and their ego,
Yes.
in a commercial setting, that is a different type of task to the arbitrator's task, but it produces quite valuable results.
So mediation might be a way to go. Does the Lagos Court of Arbitration promote mediation?
Oh, absolutely. We have a mediation list. And we have leading mediators on our board of directors.
Okay.
And they're training and teaching people mediation. We have training courses. We have schools. On Saturday, there's the continuation of a beginner's class in arbitration and international
Where does
mediation.
that course hold?
At the International Center for Arbitration and ADR, which is the home of the LCA, which is at Lekki,
Okay.
which is a Okunde Blue Water Scheme, Remiolo Wode.
Yes.
It's a huge, the ICAA, as we call it,
Yes.
is the first purpose-built arbitration center in Africa. Now, I've seen arbitration centers in London, the International Center for Dispute Resolution. I've seen the Maxwell House in Singapore. These are the models, more so the Maxwell House. We create a center because one of the challenges is the logistics.
Right.
So if we have an arbitration in Lagos, can we get transcribers and stenographers? Can we get a room that has breakout session rooms? Can we have a room that has seating and arrangements? So all those things have been used in the past as
Excuses. Yes.
if you like,
Yes.
for the incapacity to hold those events. Oh, well, we're happy to decide a Nigerian dispute, but we'll do it in London, it's more convenient. But we say, no, you can do it, everything you want in London, we have it at the ICAA. And so you can come there, and people have come. I've conducted arbitrations there myself with international parties. We have taken evidence by satellite from New York and from Paris.
Really?
And cross-examined witnesses who are sitting in New York while we're sitting in Lagos. So there's no excuse. The witness can't come, both parties agree, and we'll take the evidence by video conferencing. Those facilities are extremely important in justifying the seat of Lagos as a place where arbitrations can hold. And we have those there. So the training, the dissemination of knowledge, the resources, the library, these are all contributions which add to the mission of the Lagos Court of Arbitration to establish Lagos as a prime seat of international commercial arbitration.
Is that training free?
No, there is a cost of bringing, like this weekend, bringing 3 lawyers, 2 from Paris and 1 from New York, to participate in that course. They're
Because
experts.
they're paid.
We have to pay them. We have to pay for their hotels, their travel. I'm going to be teaching on Saturday, so it's okay. They can afford not to pay me.
Yes.
We can't afford not to pay the lawyer from New York.
Yes. Okay. So what kind of costs are we looking at? How long does the training take?
The beginner, it's a 6-week training, which goes on every Saturday. So the whole day of Saturday, you come there. And
At
it's
9 in the morning.
9 in the morning to 5 in the evening. It's a practice based. There are model scenarios. There's a genuine exploration of pertinent disputes in the process of arbitration at various stages. It's 180,000 naira, and I believe that the advanced course, which starts in September, may be slightly more expensive. I can't confirm right now.
Yes.
But power for your buck. It's a highly valuable thing to acquire.
Will the trainees be giving certificates?
Yes, there's a certificate which proves that they've participated, and we're also working in conjunction with other arbitral institutions. You know, LCA is organized to be a home for a number of other arbitral institutions. We have a common mission. The Chartered Students of Arbitrators, the Lagos Center for International Arbitration, which is by the Lagos Chamber of Commerce, Maritime Arbitrators Association of Nigeria, and a number of others recognize that the facility that we have is open to them. We do not wish to create a competition with any institution. We wish to facilitate the growth of arbitration and ADR across the nation in cooperation with all these institutions. This is something that African arbitral institutions have failed to recognize in the past, that we come from a weaker side of the bargaining table, and even if we want to be regarded with value and importance internationally, we have to work together. So we work with the Kigali Arbitration Center, the Kenyan Center, the Ghanaian Center. We provide facilities, we work with them, we support their mission because it's a common mission, and it's a traditional facility which Africans should find very easy to adhere to. So we work together with all these institutions, and I was speaking at the beginning about the Chartered Institute. So many of these institutions are working to try and find a joint certification. That is in progress, because they recognize now that the quality of the training that is being provided by the LCA is so top class that it helps to subscribe to that. And that is increasing the situation.
Obviously, you must be a lawyer first before coming to specialize to be an arbitrator.
No, that's not so. In my mind, in all the years I've practiced as an arbitrator or either as a counselor before, the soundest decision that I ever obtained was given by an architect who had no legal training. I talked about the lawyerization of arbitration. When you choose an expert in the field, he should be able to go zero into the subject matter. And in that case, it was quite amusing because both sides were senior advocates of Nigeria, and we cited a whole series of laws and cases and reports, and there were stacks and stacks of decided authorities in the Supreme Court of Nigeria and the Supreme Court of the United States. And he gave a maybe 30-page decision. He didn't refer to a single legal authority. He used his common sense, which happened to have complied with the law. He gave a decision which was easy to read, easy to understand. It was so simple that it was so effective. Very often with things that involve language, simplicity is extremely powerful. And the parties couldn't interfere with that decision. And shortly thereafter, even though one party threatened to challenge it, they decided it was best to reach a settlement between themselves. That is the ambition of arbitration. So we have engineers who are arbitrators, shipbrokers, insurance brokers, doctors. The key thing is your skill and expertise in the area, your ability to understand the issue. If you have a complicated oil and gas construction or such contract, you want someone who has experience to understand what is at issue. But the training is to give that person the capacity to make it effective. The effectiveness of the award depends on the skill in traversing the law which gives the system for recognizing it. You have all the expertise and you don't know how to create a proper award, it's going to be set aside very easily.
You lived in Kano. I found that interesting for about 7 years before you moved to Lagos in 1990. Was there any difference living in Kano and living in Lagos?
You know, Kano was one of the great commercial centers of Nigeria. I say was because for many reasons, and I suspect that there's some sort of a resurgence right now, which gives me delight. Many of my friends refer to me as a Kano boy, and I delight in that description. Kano was a huge center of industry, huge center of commerce, history. Over the centuries it has been, the decline of industrial capacity across the nation is witnessed in Kano. Many distractions, social, ethnic, religious distractions have damaged the commercial aspect of the life of Kano. But it's something that can, because people from Kano are traditional merchants. So it was great, and when I went there was a huge amount of economic activity. We represented a huge number of industries in plastics, in oil milling, flour milling, confectionaries. Many of those businesses have lost their way and collapsed because the environment was not created by previous governments. The master plan that was created for Kano, perhaps a much unappreciated governor, the late Adu Bako, is part of the master blueprint that still operates and will sustain Kano ultimately.
I wanted to talk about your defense in the Lagos State government with the vehicle registration documents and driver's license. That is a case study. And I was thinking about you going ahead with that case. Did you not feel limited by cultural limitations? How you be perceived in Nigeria where a state government doesn't take the federal government to court? I mean, the federal government is always looked upon as the headmaster or the principal, and then there you are suing the federal government on behalf of the state government. Take us through that. Was there any backlash as a result of you doing that?
I find that through life, through my legal practice, I've done cases that may be regarded by people who have this sort of concerns as provocative. Oil and gas matters some years ago, about 10 years ago, it's quite a major litigation where we took the Minister of Petroleum to court.
Yes.
And I've never considered that to be a limitation. It's a matter of law. I have no personal interest, I have no personal animosity. I don't take cases personally, but I will organize the facts and I will organize the legal case to the best of my ability. And so I really don't give any thought whatsoever to what people may feel. I'm not begging anybody for favors.
Yes.
So I don't want any contracts. So
You're not looking for contracts. Thank you very much, Mr. Candide-Johnson, for coming on the program.
It's a great pleasure. Thank you very much.
And thank you for watching. I'm Angela Ajitomobi.